In today's video, let's talk some more about FDA and FTC issues in consumer products that focus on health, wellness, lifestyle, or fitness. I'm Michael H. Cohen, founding attorney of the Cohen Healthcare Law Group. We've had the pleasure to advise over 1,000 healthcare industry clients on healthcare and FDA legal issues. Our clients include healthcare startups that do lots of things like integrative medicine, functional medicine, coaching, telemedicine. Maybe they have a management services organization or MSO serving as the management and marketing arm, whether they've got a brick and mortar setting, via digital and mobile health, via glasses, via some way that transmits to humans. They have a slew of innovative health, wellness, lifestyle, and fitness products. Both consumer products that are physical, like gizmos you put in your briefcase. Maybe we won't even have briefcases by the time you watch this video. But they're things that are going to move the needle on your health, like my Fitbit here. Okay, free product placement, but 2 points in this video. First, whenever you put out a consumer product that has a health, wellness, lifestyle, or fitness component, the first question is whether the product could be considered a medical device that's subject to FDA medical device regulation. To decide whether a device is subject to FDA medical device regulation means you have to determine the device's intended use. To determine intended use, the FDA looks at a product's labeling claims, advertising matter, or oral or written statements by manufacturers or their representatives. So it could be something you say or see on your website. Now, generally products are considered medical devices, again, if intended objectively for a medical purpose. Let's look to the definition in the FDCA, which is an instrument, apparatus, implement, machine, contrivance, implant, in vitro reagent, or other similar related article, including any component, part, or accessory, which is ... intended for use in the diagnosis of disease or other conditions, or in the cure, mitigation, treatment, or prevention of disease in man, meaning humans, or other animals. FDA also regulates radiation-emitting products. These include tanning and therapeutic lamps, black light sources, white light devices, art-form lasers, and infrared alarm systems. Second point is that you'd be amazed at how extensive FDA's regulatory framework is, and just how much it covers, as well as how specific the legal rules can be. As just one tiny example, one of our clients was interested in marketing a number of products that used light to do certain things, like help someone achieve weight loss, help someone achieve better sleep, whatever it was. Well, it turns out that FDA regulates so-called light therapy devices as Class II medical devices. And one such device is cleared to treat wrinkles. Who would have thought that? In our research, we found out that FDA published a document called Memo to the Conference of Radiation Control Program Directors on Red Lamps for Skin Rejuvenation being installed in tanning beds booths. You get the picture of how FDA speaks. Now, it's very specific and very deep in the weeds. The point is, FDA addressed this very fine point, and the client's market opportunity had to be evaluated in light of FDA's regulatory framework, including everything that we unearthed in our research. So in this document, for example, among other things, FDA addressed lamps that emit red light. Again, super specific. Who would have guessed? This is FDA speak. And this is what you have to pay attention to when you put out a product to market that has to do with health, wellness, lifestyle, and fitness. Thanks for watching. If you still have questions, click on the link below, cohenhealthcarelaw.com/contact, to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.